My name is Matthew Chrisman. I teach philosophy at the University of Edinburgh, and today I want to talk to you about obligations to obey the law. There are laws of nature and laws of human. When are we obligated to obey the laws of humans, and why? It may seem obvious that we should obey the law. After all, if lots of people were to go around murdering and stealing, or even just driving on the wrong side of the road, society would grind to a halt. And even if just a few people broke the law, the rest of us might rightly resent those people for not playing fair in our collective pursuit of the benefits of mutual cooperation. We should remember, however, that the laws of some societies are whimsical dictates of an evil despot. And even if a society isn't fundamentally unjust, still, some of its laws may be unjust, either in what they tell people to do or in how they're reformed. So there can't always and everywhere be an obligation to obey the law. For these reasons, political philosophers and legal theorists have sought a principled way to draw the line between when there is and when there isn't an obligation to obey the law. The basic question is this: what grounds or explains the obligation to obey the law in societies where we think there is such an obligation? To begin to answer this question, it's helpful to observe a distinction between merely complying with the law and obeying the law. Compliance involves doing what the law says, but not for the reason that it's the law. For example, one might drive below the speed limit to avoid punishment, or because one happens to want to do so. By contrast, obeying the law requires acting, in part, for the reason that the law prescribes the action. For there to be a moral, or all things considered reason to obey the law, many philosophers and legal theorists have thought that the institutions that make and enforce laws in society must have a special kind of authority, the authority to prescribe actions to members of society. What could confer such authority? Traditionally, many people thought that only God has absolute authority to tell people what to do. So one might think that it's only through the grace of God that some institutions, such as the monarchy, have the authority to make and enforce laws that people have an obligation to follow. It's no wonder that while this God-based answer to our question prevailed, societies went to war over disagreements about which kings or queens really had the true grace of God. As religious conviction in many parts of the world has become less dogmatic, political societies become more multi-faith and multicultural. And as a result, this traditional account of the obligation to obey the law has fallen out of favor. Nevertheless, most political philosophers and legal theorists still think that the law merits obedience, at least in some societies. Why? Here's one popular way to motivate this idea. Think of the law as an institutionalized solution to a coordination problem. The problem of finding a set of widely enforceable social rules, compliance with which allows us to reap the rewards of mutual cooperation while mitigating the risk of harming each other's interests. Then the question becomes, what gives us a reason to obey these rules, especially when we could advance our own individual interests by disobeying them? Two popular answers have to do with consent, not actual explicit consent, but hypothetical or tacit consent. More precisely, hypothetical consent theories say that if someone would have consented under the right circumstances, then that's enough for the law to merit their obedience. Tacit consent theorists say that certain actions, such as living in a particular territory, not explicitly objecting to particular laws, etc., are enough to show that one consents tacitly to the laws. The main challenge to these consent-based theories is identifying a set of circumstances or actions that plausibly generates hypothetical or tacit consent. Another popular answer to our question appeals to the idea of what's fair in our collective cooperation with one another. Society might be thought of as a scheme for cooperation in pursuit of mutual benefit. If so, then there are going to be some ways of participating in society which are fair to one's fellow members, and other ways that are unfair. In light of this, fair cooperation theories say that obeying the law, at least in societies genuinely organized around mutual benefit, is what fairness requires of us. The main challenge for fair cooperation theories is to justify the claim that obeying the law really is required for achieving mutual benefit fairly. Mere compliance with the law might be all that's required for achieving mutual benefit. Moreover, fairness might recommend specific treatment of specific people without requiring following the law because it's the law. In summary, political philosophers and legal theorists are interested in what grounds the obligation to obey the laws made by humans, in cases where we think we actually have such an obligation. Obeying the law is more than just complying with it. It's taking the fact that some action is prescribed by law to be a reason to perform it. Traditional God-based attempts to ground such an obligation are difficult to make convincing in a multi-faith context. Other theories seek to ground this obligation in hypothetical consent, tacit consent, or duties of fair treatment in cooperative schemes.